From Studio 226 in Orlando, this is Aging Smarter. Aging Smarter is a podcast focusing on making it easier to grow older, to prepare for the future at any age. Why? Because aging is something we all have in common, regardless of what demographic we come from. Now, this podcast aims to educate, to entertain, to prepare, and to amaze you about your life's journey. Again, regardless of your age. I'm your host, retired and former circuit judge Jose R. Rodriguez. Today, we're going to be tackling one of the most profound areas of guardianship law. What happens when a ward becomes terminally ill? How do we balance autonomy, protection, and court oversight? What does the law require when life-sustaining treatment decisions come into play? Now, to help us unpack all of that, I'm joined by Mercedes Da Silva. She's a third-year law student at Barry University School of Law and technically a 2026 Juris Doctor candidate, which means she'll have a JD after her name and ready to take the bar exam. I know she'll pass it, and then to practice law. She has studied and conducted extensive research in the areas of guardianships and end-of-life law in Florida. Mercedes, welcome to Aging Smarter.
Thank you, Judge. This is a really important topic and one that so many families and practitioners struggle to navigate, especially when emotions and ethics collide.
You know, absolutely. Florida's guardianship system really sits at the crossroad of ethics, medicine, and the law. At its core, it's about balancing three principles: autonomy, a person's right to make their own medical decisions, and protection, the state's duty to safeguard vulnerable individuals, and oversight, the court's ongoing responsibility to ensure that guardians act with integrity.
Exactly. And when a ward becomes terminally ill, those principles don't disappear. They actually become even more important because decisions are so deeply personal and irreversible.
You know, why don't we start with the process? In Florida, under Section 744.4431, let me say that again because I'm not good in math, and I don't expect anybody else to be whiz. So it's Section 744.4431, if you're taking notes. A guardian can't just decide to withdraw life-prolonging treatment on their own. They've got to get court authorization.
You're right, and that comes directly from the Florida statutes and Florida probate rules. The Florida Supreme Court's ruling in In Re Guardianship of Browning made it clear that every person has the fundamental right to refuse medical treatment, and that this right to decline medical treatment does not disappear if you become incapacitated.
So, the guardian in those cases has to file a motion and justify to the court what the court would have wanted. That's called substituted judgment.
Exactly. They can rely on things like a written living will, an advance directive, even statements the person made about their values or beliefs. But if there's no clear directive, the guardian bears a heavy burden. They must show by clear and convincing evidence that this is what the ward would have chosen.
You know, it seems to me that the better and the more that the guardian knows the ward, the easier it would be to make those life-sustaining or life-defining decisions. When that's not the case, it does in fact become a very heavy burden. And that's not a light standard that we were talking about. They also need medical testimony, typically from the attending physician, confirming that the ward is terminal, that the ward is end stage, or in a persistent vegetative state.
And you can't forget about notice. The guardian has to notify all interested persons. And if the ward receives VA benefits, even the U.S. Department of Veterans Affairs has to be notified. It's all about transparency in due process.
Absolutely. Now, let's talk about DNRs, do not resuscitate orders. That's another very sensitive issue.
It really is. A guardian can't consent to a DNR without approval unless two very specific conditions are met. The ward is terminally ill at the hospital and no one in the family objects. Otherwise, you have to petition the court again.
Yep. The safeguards of court oversight comes from lessons learned, like the Shivo case. and more recently, the case of a professional guardian who would routinely have her wards fill out DNRs when she made the call that the ward's quality of life was poor. Forget about contacting members and getting their input. These cases taught us how complex and emotionally charged these decisions can be. So the legislature reenacted some laws to go ahead and require that DNRs, when you're dealing with a professional guardian, were the subject of court approval, and requiring much more work for the courts and for the lawyers. And of course, it was all in the name of oversight.
Absolutely. It's not just about bureaucracy and making it more difficult. It's about ensuring that the court is a neutral protector of the ward's rights and dignity.
Well, there was another interesting case involving a DNR that teaches us how doctors make ethical decisions in order to honor patients' wishes. Several years back, a 70-year-old man was admitted to the emergency room at Miami's Jackson Memorial Hospital. The man was injured and unable to communicate. He had a tattoo on his chest that read in large letters, "Do not resuscitate." There was a concern as to whether or not to honor the tattoo because that request was not on yellow paper and didn't have the signatures that were required under the rules of the Florida Department of Health. Imagine, do not resuscitate. It's not in paper, it's your chest. And of course, what do the doctors do? The doctors didn't quite freak out. They went ahead and they called for an ethics consult. Those of you who watch ER know what that is. But the doctors, after the consult, determined that the DNR would be ordered because first, the tattoo was of good quality. Certainly not in the position to determine what is and isn't a good quality tattoo, but somehow the doctors did. And two, it had what it seemed to be a signature. So the doctors reasoned that the man had gone out of his way to express his wishes in a very, very permanent way. So, after the process of ER, of again, recognition that, again, if the DNR had to be executed, the doctors would comply. Later, the man comes to, and they find that the DNR was supported by a written DNR that the individual had at the living facility where he was staying. So in other words, the tattoo focused on the intent of the DNR. The DNR was also on paper later on. Luckily, they never had to use the do not resuscitate or CPR because of the fact that, again, the man came to. But those are reasons why you need to make sure that if you're going to go ahead with a DNR, that you make it in as much of a clear and absolute focusing on your intent, to communicate that much better than anything else. So I guess a tattoo could have worked, but I would not recommend to anybody just go ahead and have a DNR tattoo because you don't know what the quality of the tattoo might be determined to be.
Now, even when a ward is terminally ill, the guardian's work doesn't stop. They still have to file inventories, financial accountings, and annual plans. Under Florida statutes, those reports keep the court informed about the ward's condition, care plan, and financial management. The annual plan especially must reflect the ward's medical prognosis and care goals, including hospice or palliative care.
It's all about continuing judicial oversight. That's one of the hallmarks of Florida's system of guardianship.
There are also times when things move too quickly for the regular guardianship process. That's when folks can step in with an injunction for protection against exploitation of a vulnerable adult.
Right. Under Section 825.1035, Florida has created an injunctive process that anyone, you don't have to have a lawyer, you don't have to be anything specific other than just a human being. can apply to the court for an injunction to prevent immediate harm and exploitation of a ward's property, health, or safety.
In other words, it's a bridge to make sure that someone has legal authority to protect the ward when time is of the essence.
You know, this is a relatively new statute, which had been sorely needed to prevent individuals from quickly draining assets from banks or disposing of the property of vulnerable adults. Let's move to the heart of the ethics.
The best interest standard in guardianship is never simple. It means considering both the ward's welfare and their autonomy. The guardian's job is to make the decision the ward would have made if they could, and when that's unknown, to act out of compassion and beneficence.
The legislative intent of the Florida statute makes it clear that guardians must act with human dignity and respect, and the decisions of the courts remind us that they are there to protect the vulnerable.
Exactly. That's what this comes down to. The guardian's duties aren't just legal. They must be deeply honorable, and those duties have to be carried out with honesty, empathy, and complete loyalty to the ward.
You know, before we wrap up, let's talk briefly about POLST, P-O-L-S-T forms, or Physician's Orders for Life-Sustaining Treatment. That's where POLST comes from. It's an acronym.
Certainly. These are medical orders that reflect the patient's treatment preferences, things like resuscitation, intubation, or artificial nutrition. Guardians need to make sure any POLST order aligns with what the court has approved and that the copies are filed with the clerk. Otherwise, you could have conflicting directions between the doctors and the court.
You know, just as a reminder, when orders or documents provide conflicting instructions, the latest in time are the ones to control. So in practice, a guardian's job is not just about getting a court order, it's also about harmonizing every document, every order, every plan of care. In other words, knowing what's going on at all times and in every single corner of that patient's life or that ward's life.
And I think that's what's so striking about Florida's system is that it's intended to never lose sight of dignity. Even in the most difficult moments, the law demands respect for autonomy, transparency, and compassion.
Well said. Guardianship in end-of-life cases is truly the meeting point between law and humanity. As the Florida Supreme Court said in the Browning case, the right to choose or refuse medical help, medical treatment, is the essential embodiment of self-determination.
And that's why guardianship work is so meaningful, because it's about protecting not just people's lives and property, but their values, their dignities, and their independence.
Exactly. That's all for this episode of Aging Smarter. If you found today's conversation helpful, please share it with a colleague or a loved one. The contents of this podcast serve as general information and should not be considered legal advice. Laws change often and differ by circumstances and location. The information provided may not apply to your specific situation. No attorney-client privilege or relationship is established. Please consult a licensed attorney in your area for legal advice. I'm Judge Jose R. Rodriguez. Thank you for listening. And remember, compassion, clarity are the cornerstones of Aging Smarter. Our showrunner is Art Miles. Our producer is Annie Rodriguez Newbern. We thank the firm of Tangle Rodriguez and Associates, who provides for a lot of our support so that we can continue to do this pro bono exercise. Remember, if you want to get a copy or if you want to listen to any of these podcasts, you can go ahead and go on the website for the Senior Resource Alliance, where you will find them all very neatly in order. Thank you very much.